Welcome to the ACLU's, this is the second in our series of quarterly CLEs, which we are hosting to try to foster, some kind of community dialogue and interaction, especially within the legal community, on topics that are particularly relevant and important, I think. Our first CLE was on the school-to-prison pipeline, and today's CLE will be on all of the assorted legal issues that tend to percolate around the issue of homelessness, which, as I'm sure you all know, is highly relevant today, particularly here in Seattle, where our city has embarked on a series of so-called sweeps of homeless encampments. So a quick note that the ACLU is a civil rights organization. We are also a membership organization. There are membership materials available outside. Out of curiosity, are any of you here ACLU members? Yay! So everyone who didn't raise their hand, feel free to come talk to one of us, or to Martha Reyes, our delightful events coordinator, for more information and their materials outside. And of course, we don't do this work alone. The panel today is co-hosted with two other organizations, Columbia Legal Services and the Homeless Rights Advocacy Project at Seattle University. No one could do this work by themselves, right? And it's only in partnership with great organizations like CLS or CLE that we're really able to make a lot of the changes that we can. And speaking of which, in terms of other partnerships, if any of you lawyers are interested, or even non-lawyers, if you're interested in working with us, whether on the issues we're about to talk about today or other civil rights, civil liberties issues, I encourage you to reach out again, either to myself or to Martha. We would really welcome that. And we have all sorts of volunteer and cooperating attorney positions available at any given moment. So I'm going to say a few words of introduction about our speakers, and then we'll really let them take it away because they really have the meat of this presentation. So our first speaker is Suzanne Skinner from Seattle U, and she has spent 30 years as counsel to various public agencies, private companies, and nonprofits, and she is really an expert when it comes to the rights of the homeless. She served for 8 years as the director of the Civil Division of Seattle City Attorney's Office. And while she was there, interestingly, she settled the city's long-standing litigation against organized homeless encampments. So this is, of course, particularly relevant to what we're experiencing today, and we were so glad that Suzanne was available to bring her vast historical background and wealth of expertise to our panel. She has also served as an administrative law judge for Washington's Land Use and Environmental Hearings Office, which has nothing much to do, I think, with this, but I thought was cool. And was a former assistant United States attorney in New York City, which is where I'm from, and that's why I mentioned that. Anne LaGarfo is our second presenter today. Anne comes to us from Columbia Legal Services, which is just such a fabulous office. I have such respect for the work that they do. And she works in the Basic Human Needs Practice Group. And her team advocates for clients through policy work, through lobbying, and impact litigation. And they work on really the right of people to access the fundamentals of life, right? There are a few things more fundamental than housing. They also work on access to food, to medical services, and financial justice. So really all around good stuff. And finally, we have Nancy Tallner, who is a senior staff attorney in our office at the ACLU of Washington. Nancy has been with the office for more than 20 years, and she has really dedicated her life to protecting the civil liberties of others. She works on amicus briefs, and she covers all sorts of issues, but of relevance today is she has a really long history of working with various jurisdictions in a lot of different ways and capacities on issues involving panhandling, homelessness, the criminalization of poverty. Nancy, although has not ever had a job in New York City, was a former appellate and tribal court public defender.
I'm going to quickly do a little blurb on Seattle University's Homeless Rights Advocacy Program project, because it's brand new, and so it's very likely very few have heard of it. It was started over 2 years ago by a professor named Sarah Rankin there, who's a human dynamo. And what the project does is essentially marshal the research skills of Seattle University law students to kind of delve into questions, substantive questions, and develop policy briefs around the whole issue of homelessness, the criminalization of homelessness, and legal rights associated with homelessness. And we also work with, the project also works with great advocacy organizations nationally and locally, such as CLS and the ACLU, to advance the rights of homeless individuals. Last year, the Homeless Rights Advocacy Project did one of the big surveys that we did was on the criminalization of homelessness in Washington State. And this kind of briefly, we surveyed 72 municipalities, basically doing a cut about everything that was above 5,000 population, and kind of did a, reviewed what those ordinances covered. And you can see from that, 78% prohibited sitting, sleeping, standing in public. There was also, they covered vast other areas as well. Essentially, two different kinds of ordinances. There are those that target homeless individuals, such as panhandling ordinances, that are rarely enforced against anybody who is not homeless. And there are those that are facially neutral, like an anti-camping ordinance. And urination ordinances. Now, in terms of discriminatory impact, there's no question that the impact is far greater on homeless individuals. And the sad thing is as sort of homelessness, visible poverty increases in our cities and our rural areas, the number of these ordinances are just escalating throughout the state. And you can see here, we found since 2000, 288 new ordinances were pertaining to the criminalization of homelessness. And when I say, I really should back up for a second. When I say the criminalization of homelessness, what I'm referring to really are ordinances that kind of are directed at basic daily life functions. Urination, sleeping, and so when they are applied to homeless people, it's essentially criminalizing these sort of necessary life activities because they're being taken in public spaces. There we go. And this is a graphic that essentially goes through just what I said. Interestingly, kind of delving to Seattle. Seattle had 7 ordinances that fall in, that are, criminalize these sort of basic conduct of, necessary life activities. But in terms of the enforcement, when the project took a look at what was actually getting cited, 71% of the citations were for camping in public. So camping in public, which is going to be the focus of my few words here, is really a hot button issue here in Seattle. And I have, as you'll probably get there's slides I'm skipping over because it's really just background material. So just briefly, what's wrong with the criminalization of homelessness? Pretty straightforward. You throw somebody in jail, homeless defendants, when they're released, they have no place else to go, they're still back on the streets. Fairly ridiculous when you really step back from it. A huge concern is that the sanction, even though the kind of sanctions that are imposed for violations of anti-camping ordinances and other criminalization ordinances can be twofold. They can be civil citations or they can be misdemeanors. In practical effect, a lot of times they end up ramping up to being prosecuted criminally, because if it's done multiply, first of all, multiple infractions can end up as an automatic misdemeanor. And then most importantly, I think, if you can't pay your fine, if you fail to appear in court, which is very unlikely, what else can you say if you actually don't, if you're homeless, plainly you don't have the money to pay a $200 fine, that can then obviously escalate into a criminal sanction. And then the irony of it all being, if you get a criminal record, then that can be a bar to federal subsidies for housing, and also a bar for employment. So it sort of basically sticks you further into the rut of being homeless. And then I think finally it's an expensive waste of tax dollars. The HRAP, the Homeless Rights Advocacy Project, tried to get a grasp on how expensive it is. And it was interesting, we did basically public records requests from the city of Spokane and the city of Seattle. And essentially, the data was horrible, let me just say, because basically things were, we could only get data, both cities only kept records for criminal violations, didn't do anything with civil infractions. So, but nonetheless, we tried to get a grasp on it. Combining those two cities for 5-year periods, they spent about $3.5 million for policing, adjudicating, and jail time associated with enforcing these kind of criminal violations. And over $2 million of that money was attributed to jail time. You know, yet these folks are released out to the streets. So finally, another reason what's wrong with homelessness, it can be unconstitutional. And that's what we're going to go to now. And I'm going to focus on 2 legal theories that have been fairly well developed in application to anti-camping and anti-sleeping ordinances. And though there's distinctions between the two, kind of in practice they get lumped together a lot. So I'm going to refer to them almost as synonyms. In a case that came out of Boise, Bellevue, Boise, there was, excuse me for a second. Bellevue, Boise involved a challenge to no camping and sleeping ordinances that Boise had on its books. Thanks so much. And it was, in that case, there were several homeless plaintiffs, and they were prosecuted with for misdemeanors and were convicted. The plaintiffs alleged in response that there were an inadequate number of shelter beds, and there were such restrictions on the shelter beds in Boise that it basically prevented the city of Boise from enforcing its anti-camping and sleeping ordinances against these homeless individuals, because it would be cruel and unusual punishment under the 8th Amendment. The situation in Boise kind of boiled down to looking at a little bit at the shelter system there. There were 3 shelters in Boise. 2 of them were religiously associated, Boise Rescue Mission, and they had a lot of prohibitions on who could enter, depending on what their kind of declared faith was, and also, you know, a lot of visible displays of crucifixes. And the allegations were that those, and there were plaintiffs, there was testimony to support that those conditions basically kept some homeless people from accessing those shelters. Also, at the same time, there was gender segregation, which there's a lot, you know, you think there's shelter beds, but not all beds are open to everybody, and certainly you know. So the Department of Justice intervened essentially in the form of a statement of interest, which is kind of like a super amicus brief, really. And the Department of Justice, in its statement of interest, basically essentially said that Boise's ordinances, you know, were criminalizing homelessness, and most importantly, the language there is, when adequate sheltered space does not exist, there is no meaningful distinction between the status of being homeless and the conduct of sleeping in public. And really, the Department of Justice went even so far as to say, no reasonable alternative did not just mean not enough shelter beds. It also required an analysis of whether those beds were truly accessible to the individuals. Now, that was all done quite vaguely, and so this is a huge, you know, topic that actually we've been looking at the Seattle University to try and develop sort of what does accessibility really mean as to homeless shelters. And indeed, we're going to be issuing a big study on this in May. Stay tuned. It's scintillating. No, but actually it'll be very good. And interesting, the Department of Justice was focusing on a split on the circuit that between the circuits as to kind of how to deal with sort of criminalization issues. And they basically, in their statement of interest, they turned to a case that's been vacated, but was a Ninth Circuit case called Jones versus Los Angeles. And Jones is an important case. It was a challenge to Los Angeles's ordinances prohibiting sitting, lying, and sleeping on public streets at any time. And in the record, there was undisputed evidence that there are more homeless people in LA than shelter beds available. The city, in its defense, contended, hey, this guy, Jones, there was a shelter that was available to him, 2 miles away. He could have walked to that shelter. The court, it was a great judge, obviously, rejected that because he said, look, this guy would have had to walk through an extremely dangerous area of town that the city concedes is extremely dangerous. That is not reasonably available shelter. And hence that, and Jones then went further and said, sleeping is a life-sustaining activity that had to be conducted somewhere. If you'll kind of remember the Powell and Robinson cases from constitutional law, and really what Jones and what Jones said is, look, the Eighth Amendment does not just assess sort of the facial construction of the statute, but its practical implications. And in kind of going back, it kind of drew on Powell, with Robinson, which is a very old case. And you'll remember that's the one that kind of creates the distinction between criminalizing status versus conduct. Robinson, involved a statute where it criminalized the possession of drugs and the status of addiction itself. Because if you were addicted, you could be born addicted, and even if you weren't using drugs, you would be violating that statute. If you had been addicted, that statute was unconstitutional. Powell followed 6 years after Robinson, and was where Powell versus Texas, and in that case, the court was considering a statute that criminalized intoxication in public. And that was a 5-4 split, upholding the statute. The important kind of determinant in that case was a concurrence written by Justice White, and it really turned on the volitional nature of the conduct prohibited. And so basically, the thesis being that if the defendant had no choice but to be intoxicated in public, it would be unconstitutional. In the Powell case, the defendant Powell had not adduced enough evidence kind of showing that he had no choice, and so the majority went with upholding the statute. But that analysis basically found resonance in Jones, and my time's up, and I have talked way too. Here's the citations. I was going to talk about the right to travel, and I guess I will. That's the second theory that. Should I just get off right now? That's the second theory.
Take 45 seconds.
I will take 45 seconds. And really, you'll remember that the right to travel is a fundamental right that comes out of the Privileges and Immunity Clause. It's subject to strict scrutiny and analysis. And so in Pottinger, which versus City of Miami, basically the court found that this very broad ordinance that Miami had passed that essentially prohibited sleeping anywhere impeded people from coming into Miami or leaving Miami. It has since been followed. Well, it was Seattle. It wasn't followed, but it was endorsed, I guess you would put it, in Seattle versus McCohay. McCohay was in that case was much more. The ordinance was much more narrowly tailored. And there are two interesting recent cases that I won't discuss right now, but they're recent as applied, if you will, apply to instances of applying. There were Everett's ordinance, anti-sleeping ordinance, and North Bend's anti-sleeping ordinances were both deemed unconstitutional based on the right to travel and for Eighth Amendment reasons. And thank you very much.
So Suzanne really set the stage for us with the laws about criminalizing camping and sleeping outside. And there are indeed plethora of laws making all of this a crime. There's also a dearth of indoor shelter. So where are people going? What are they doing? Well, they're out there, and we see them all the time. And there's a lot of activity right now happening in our city and around the country around homeless encampments and around sweeping homeless encampments. So just for some background, what is a sweep? So the city of Seattle used to call cleaning up encampments sweeps. Now they tend to use the word cleanup, but let's be very, very clear. This is not picking up your kitchen after your dinner guests went home. This is not cleanup. This is removing people and everything they own from an area. What happens after that really depends on the area and what's somebody's call. We don't really even know how, but some areas get fenced off, some areas don't. Some areas get monitored for future activities, some areas don't. In some cases, everything is thrown away, people come back, they restart their lives again in the same location, except without their tents and without their documents and without their sleeping bags, but they start over and they're not swept again. So it's a little mysterious, but that's basically what a sweep is. They've been going on in Seattle for decades. In 2008, because of some advocacy, both from legal advocates and service providers, the city did agree to a process for how sweeps would be conducted, and that's the link there. They're called the multi-departmental administrative rules, and they govern how sweeps would be conducted. Their main provisions are for some form of notice sometimes in some circumstances, and for the protection of property that's picked up by the sweep teams in some circumstances at some locations, and only for property that is deemed to be worth at least $25 on the retail market. So an old backpack filled with everything someone owns. Is it the backpack that has the retail value of $25? Is it the social security card that's inside? Is it the cell phone, $10 cell phone that's inside? Who knows? But there is a series of rules the city's supposed to be following. Part of the problem is they aren't broad enough, as I just discussed. Part of the problem is that they're not always followed. And the other part of the problem is that a lot of the land in the city is actually owned by the Washington State Department of Transportation. And Washington is not bound by the MDARS. Washington has its own much more loose policy, more or less may post a 72-hour notice that may or may not have a correct date and may or may not even be close to where the sweep is. And then as far as we can tell, all the property is thrown away. We don't have any individuals that we have talked to that have had a different experience other than the property being thrown away. So that brings us to our state of emergency in November 2015, where the mayor and the city actually put some money and some effort into providing additional services for homeless people. Part of that, though, was also a commitment to those who live in Seattle. They won't have to look around and see people living outside. So a commitment to increasing sweeps. So more services, which was good, but more sweeps as well. And again, the sweeping was at a higher level than the services offered. So we've got in January 3,000 people sleeping outside in the city of Seattle. That's not 3,000 homeless people, that's 3,000 people outside of shelters. So it's clearly still a problem. And since the state of emergency in November, a couple things have happened that have made homelessness actually more dire and more problems with encampments. And that is, we're now in the spring, and almost half the shelter beds in Seattle are for cold weather only. And so they close because everybody sort of agrees that in the summertime people are sleeping outside. So how are people sleeping outside? And they're also being swept, and they're also being criminalized. It's hard to understand how this all makes sense as part of a cohesive plan, but that's what happens. People, you may know that $1 million has been allocated to the Washington State Department of Transportation to fence off the jungle, which is where an area near I-5 where a lot of people sleep. Don't know how that money is going to be spent. A lot of pushback on the fencing, even from law enforcement, but if it does get shut down, those people will go somewhere. And then I don't know if you read recently, SHARE, which runs a lot of the shelters in the city, as well as the authorized encampments, closed 15 shelters last week in protest over the lack of funding. So where are all those people? Where are they sleeping? I suspect they're sleeping outside. So this is a picture of a tent in an encampment, and you can see this individual has made an attempt to decorate their home for the holidays. This picture was taken in December. Sorry. Oh, and this is the picture of a homeless individual in the middle of a sweep. This woman was attempting to carry off her tent and all of her belongings before the city confiscated her belongings. So this is what it looks like when somebody tries to haul away everything they own in 15 minutes. Okay, case law. The case law on sweeps, the most successful cases and the vast majority of cases have looked at the Fourth Amendment under the Constitution, and they're usually constitutional cases. Pull them all up here. Fourth Amendment being the big one, the vehicle being Section 1983, where you can sue a state actor for constitutional violations. And out of all of these, the most important one is the Lavin case. That actually is the same population of homeless individuals living on Skid Row in LA that were involved in the Jones case that Suzanne talked about. And so after they were no longer ticketed for living there, and probably at the same time, their property was continually being seized by the city of Los Angeles. And why this case is so important is, well, first of all, it's the Ninth Circuit, so it's important to us, but it's very important nationally because the court found that there does not have to be a privacy interest in a homeless person's property to stop the city from seizing it. In other words, you have constitutional protection for your property, even if it appears to be abandoned, and even if other people might not think that that's something you consider private. So if you leave your tent or a shopping cart full of belongings on the sidewalk, that cannot be seized improperly, even though arguably there's no privacy interest in leaving things out and about in public. So that was a big case, big change in the law. I don't have time to go through all of the cases, but Kincaid was interesting, large settlement, $1.4 million. It was your basic sweep. Police came in, took everything, threw everything away. And they agreed to new procedures for sweeping, but as we'll see soon, it didn't last, and there was yet another case, and there still is, I think, going on against the city of Fresno. And then Martin v. Honolulu, the plaintiffs actually lost their request for temporary restraining order, but did get the city and county to enter into a stipulation in January. And I believe the ACLU was involved in that. Most of these cases they were. Did get a stipulation around procedures in Martin. And then Pottinger was also mentioned by Suzanne. It's an older case, but it's got some great law. Okay, 14th Amendment, procedural due process. I got to speed it up even more. This is your right to notice before your property is taken away. This is your right to get your property back after it's taken away. And this theory is in most cases involving the taking of homeless person's property. But a more interesting case, so I'm going to highlight it, is the Sanchez case. This is, again, the city of Fresno that I mentioned earlier. And what was interesting here was the court found substantive due process rights for the homeless. They found that there was an interest in bodily integrity and that the city had created a dangerous situation by seizing and destroying shelter during cold months, putting people in danger. And so substantive due process, for those of you who are constitutional scholars, it's usually used in areas like marriage and procreation, your big liberty, fundamental interests. There's not a fundamental right to housing in the United States. There's a lot of case law on that, but this has been an interesting case to see what we can maybe do with that. Moving away from the Constitution, I wanted to talk for a minute about other theories that we can look at involving sweeps. One is the ADA, Title II, which prohibits discrimination against persons with disabilities. And this is a case, I have a cite here, a quote here from a case that is not related to sweeps, but it does relate to accommodation by public entities. And there's 3 different theories that you can look at on behalf of individuals with disabilities. That's outright discrimination, disparate impact, and failure to reasonably accommodate. And where this gets really interesting in the sweep arena is that the city itself and everybody acknowledges that a lot of folks out there homeless suffer from mental illness or live with physical disabilities, and it's both a cause and an effect of homelessness. And so some ways that we can see this play out during a sweep is mental illness or physical disability can impact the ability to read a notice, to understand a notice, to know what to do about a notice. It can impact the ability of an individual to move their belongings. It can impact the ability of an individual to move themselves around the city or the county as they're sort of chased from encampment to encampment. It can impact the ability both cognitively and physically to access the phone system, to try and find property, to access the warehouse where the property is stored, and to bring the property back to wherever it was taken from in the first place. So Title II of the ADA, we haven't seen cases on that as applied to sweeps, but I think it is going to be an interesting area. Eighth Amendment, Suzanne already talked about briefly. At the end of the day, if it's against the law to trespass on private property, if it's against the law to sleep in doorways of Macy's, and you can't sleep in the greenbelt without getting swept, then really what you've done is made living outside, and in fact, living at all a crime. And so I think that there's room in the Eighth Amendment to look at sweeps through that lens and see if there's any traction. And in particular with vehicle residents, with the ticketing and impounding of vehicles, which are also a person's home and also the only asset a person has, I think there's some room in the Eighth Amendment to look at that as well. Here are some recent challenges that I have listed up here that have been filed in the last year or so to sweeps. I want to just highlight really quickly, because I know I'm out of time, sorry. Pull the complaint in Ellis if you have time. This was in Vancouver, and it goes one by one by one by one for each plaintiff, why the plaintiff was away from the encampment and what the plaintiffs lost. And those stories told in that complaint are the exact same stories that we hear when we talk to people who are subject to sweeps in Seattle. And what were they doing? One person was out at a medical appointment, one person was helping another homeless individual, one person was at a temporary day labor job, one person was out getting breakfast, one person, we don't really know why he was out. Maybe it was for a bad reason, or what we consider bad. Maybe it was for a good reason. But it's the same family of stories that we hear when we talk to people. People are living in these encampments for different reasons, and they're leaving their stuff there. They're living their things for life there during the day for a reason to go somewhere. And that complaint in particular is very illustrative of what people lose and why people are gone. And then I just want to point out, it's not just cases in litigation. There's also some efforts on the legislative front, and the city of Indianapolis and Marion County just passed an ordinance with 3 key provisions. Sorry, I'll just tell you them. One is 15 days notice before a sweep can happen. One is that service providers must know that the sweep is going to happen and be engaged with the encampment before the sweep can happen. And most importantly, there cannot be a sweep unless there is transitional and permanent housing for everyone in the encampment. So this type of legislation can be very helpful. It's very recent. It was just passed at the end of February, so we don't know how it'll play out. But that is another area that we are exploring for the city of Seattle, for Washington State. So thank you.
Mentioned that ACLU nationally has done a lot of the homelessness related cases, even more so the ACLU around the country has done the panhandling cases, The obvious connection being that begging or asking for money is considered free speech, and we're going to talk about that. So also along the lines of the ACLU doing a lot of the panhandling cases, there was just a new case filed yesterday in New Hampshire by the ACLU of New Hampshire, also challenging a panhandling law. So we're still at it, still working on this. So one of the things we're going to talk about is the Reed case. This is it's mentioned in the materials a little later. This was a case from June 2015 from the U.S. Supreme Court, and it was a case that had to do with sign laws and sign regulations. But the reasoning of that case really changed the law on this subject, and has been in a number of cases applied specifically to panhandling case that in fact there was a companion case to that in the U.S. Supreme Court that was a panhandling case. So they decided the sign case, and then they said, oh, you got to deal with this panhandling case as well. So we're going to talk about that in a minute. I was a point that Reed makes, and that a lot of the cases have made since then, and the key to the First Amendment analysis is what they call either content discrimination or content-based regulation. That's now the key point of whether an ordinance on panhandling violates the First Amendment or free speech rights or not. So this is just a little visual about what that means. What does content-based regulation mean? The first two slides are photos of an event. This happened in Mukilteo and a few places in Snohomish County. They called it a happiness sprinkling. And basically it's people made these signs, and that's just an example of one of the signs. And then a whole group of people stood along the sidewalk, along the city street. This was actually near the Mukilteo Speedway, which is more like a freeway. I mean, people are going really fast. So there's a whole bunch of people with their signs, waving them around, standing on city street, with their, positive happiness sprinkling messages. None of them got arrested. Everybody. Keep in mind, Mukilteo has one of the strictest anti-soliciting laws of any of the places in Washington. It says you cannot solicit for money for charitable purposes without registering and getting a permit, period, anywhere in the city. But nevertheless, this activity everybody thought was great. It was a public service that we were spreading happiness by standing along the street with the signs. So public service, not a crime, nobody got arrested, everybody thought it was great. This is a photo of a woman in Portland, Maine, which was also another case where there was panhandling litigation. Her message is pretty much the same as the previous people. It's not a downer message. It's homeless, not helpless. Homeless. Anything helps. God bless. Very common for people to stand on street corners. You see in Seattle all the time. Say God bless. But a very, very positive message. She said, homeless, not hopeless. Very similar message. And she's standing, in essentially the same kind of place along the city street. It happened to be in median, and some of the litigation is about that fact. But the problem is, she was arrested. She was arrested for illegal panhandling. And so the point that the Reed case makes, and we're going to talk about this in a minute, is that's why it's content-based regulation, and that's why it violates the First Amendment, because it's the nature of the message, where one person's message, which is very similar, is okay, the other one's isn't. Keep in mind, and this is something the Reed case made clear, you don't have to prove this in order to win on the First Amendment. All you have to do is look at the ordinance itself on its face, and if it could be used differently in these different situations, so one's a criminal and one's not, that's the constitutional violation. You don't have to prove that, get these photos and prove that there's one person that's okay and the other one isn't. So anyway, that's what content-based regulation looks like. So what about the legal technicalities here, the legal issues? A whole bunch of cases here. So, and both U.S. Supreme Court and then federal circuits and then Washington cases as well. These cases all have language saying begging or panhandling or soliciting. They use different words or different ordinances, but all of those things are protected free speech. If that's what you're doing, if you're holding up a sign, if you're saying, I need money, any form of that is protected free speech. They vary as to what kind of case they actually were. Only some of them were panhandling cases. I would say that the speech case in the middle from the Sixth Circuit is probably the strongest one of all of those. Not only did it go on and on about why begging is free speech and how important a message it is, but it also ended up, concluding that the ordinance there was unconstitutional, and great legal reasoning explaining why that was unconstitutional in that case. The other cases really vary. Village of Schaumburg is a charitable solicitation, but they said, yeah, that's free speech. The Williams-Yulee case was actually totally different. It was a judicial campaign speech regulation and a judicial conduct violation to do campaign speech. That the result of that case is not so good for the First Amendment, but in the course of their discussing that, the court said, yeah, asking for money, including panhandling, things like that, has always been considered free speech. So that's why that's on there. The other cases you can read as well. They all do involve panhandling to some extent. Seattle versus McConaughey was the Seattle a long time ago passed an ordinance, and it still is illegal to sit or lie on the sidewalk. And so in that case, they again acknowledge that holding up a sign or begging is free speech, but if you sit down or lie on the sidewalk to do your begging, that's conduct instead of speech, so it's okay to make that criminal. They said you didn't need to be sitting down to do the begging, so that was how that case came out. Also wanted to mention the roulette case. This again was Seattle, and again mainly had to do with the sit and lie ordinance. But another really important part of the roulette case from way back then, 1990s, there was another part of the Seattle ordinance that said it's a crime to engage in aggressive begging. And the court looked at that, the federal court looked at that, and they said, if we just looked at that language, it would not be constitutional. We would strike it down under First Amendment. But what we can do is we can interpret a way that ordinance is constitutional. And the way the judge interpreted it was, if it's truly aggressive begging, and I'm going to tell you in a minute what she meant by that, what the judge meant by that. If it's truly that, then it's just like a crime. It's kind of like assault, or it's kind of like robbery, where you're by force taking someone's property. So if you're actually threatening someone, so if your form of panhandling is to actually threaten someone so that they're in a criminal way forced to hand over their money, that's what aggressive begging meant, and that was okay to make it a crime. But not everything else. Unfortunately, the problem that we're going to talk about is most of the cities in Washington seem to pay no attention to that, because they call all kinds of things aggressive begging when it's not what we just talked about. What the judge said in the roulette case was, let's see. So the way she was interpreting the constitutional form of aggressive begging was begging with intent to intimidate, under circumstances where it's what's called a true threat, where it's intent to intimidate and a threat that would make a reasonable person fear for harm to their person or property. So you see what that's criminal. That's a whole different thing than holding up a sign.